देखिए, ये वीडियो मैं बना रहा हूँ उन लोगों के लिए जो मेडिकल नेग्लिजेंस का शिकार हैं। देखिए, मैं जो लोग मुझे फॉलो करते हैं उनको पता है कि मैं एक केस कर रहा हूँ जिसका नाम है सिमरन छाबड़ा मर्डर केस, जिसमें एक 22 साल की लड़की की डेथ हुई थी बिकॉज ऑफ मेडिकल नेग्लिजेंस। अब उस केस में हमें काफ़ी हद तक सफलता मिली है। तो इस वीडियो को बनाने का पर्पस ये है कि जब से वो मीडिया में पॉपुलराइज हुआ है सिमरन छाबड़ा का केस, तब से काफ़ी लोगों ने मुझे अप्रोच किया है टू टेक अप देयर केसेस ऑफ मेडिकल नेग्लिजेंस, और मैं हर केस नहीं ले सकता बिकॉज ऑफ माई बैंडविड्थ इशूज़। एंड सेकेंडली, मैं तो सिर्फ गुड़गांव दिल्ली में अवेलेबल हूँ, उसके बाद मैं काम नहीं करता। तो ये वीडियो उन लोगों के लिए है जो हिंदुस्तान के सारे कोनों में हैं, तो इसलिए आई ट्राई टू स्पीक इंग्लिश एज मच एज पॉसिबल। And if in case you are an advocate who are handling the medical negligence cases, or you are a victim of medical negligence, this video may be of little help to you that what did we do right, or what things we should have not done, so that may help you in pursuing your cases. Look, first of all, we have to understand who is the adverse party in this case. It's very easy to say the adverse party is doctor, but understand from a philosophical point. Once, if in case you will understand from the philosophical point, then you will understand how others our battle is. Look, what separates a living being from a non-living being is one trait called consciousness. Consciousness means, there may be many definitions, but the way I define is, the consciousness is nothing but the capability to tolerate suffering, to bear suffering. हम सफरिंग को, पेन को पहचाने तो उसको कहते हैं कॉन्शियसनेस। बट कॉन्शियस तो उस हिसाब से देखें तो सारे जानवर, पशु पक्षी, पेड़, हम लोग, वी ऑल आर कॉन्शियस, राइट? बट देन देर हैज़ टू बी समथिंग विच हैज़ टू सेपरेट अस फ्रॉम अदर बींग्स। क्या चीज़ ऐसी है जो इंसानों को जानवरों से अलग बनाती है? हाउ आर वी डिफरेंट फ्रॉम एनिमल्स? That is not consciousness, that is conscience. And what is conscience? Conscience is ability to decide between right and wrong. Now understand, if in case a person doesn't have the capability to decide between right and wrong, he doesn't have a conscience, और conscience यानी ज़मीर उसके अंदर नहीं है, he is nothing but an animal. Now the reason that I have said this is that if there has been a mistake committed by a doctor, and he admits and pleads guilty or feels sorry to the victim, then he has taken right decision and can be called as a human being. But if in case, despite committing wrong, if he continues to lie, if he continues to fight with the victim on wrong grounds, then he has taken wrong decision. It means he lacked conscience, so he is nothing but an animal. So understand, we are here having a fight with a beast, and the beast unfortunately is one who is educated and who has a high level of IQ, and most importantly, who has a very high flow of resources, both money as well as the power he wields in the society. So first of all, understand that your battle is with a very, very formidable opponent. So that's the first challenge, and hence you cannot take the battle very easy. In Simran Chabda's case, our battle was not very easy; it was very hard fought. Kudos to the family who stood by all the pressures. Now coming to the main point, that what did we do right in this case? First of all, I'll give you a hypothetical case. After that, I'll give you 3 real life cases, in which one case I'll take the name and rest of the 2 cases I'll not take any name, because I don't have the consent. I have not obtained any consent from the family of the victims. Now, assuming there is a patient who has to be treated for some heart disease, and he has to undergo open heart surgery. Okay, so the doctor takes the patient in. After about an hour or so, he comes out and he says that the patient, that it was a high risk operation, the on-table death of the patient, the risk of on-table death was say about 30-40%. So unfortunately, the patient could not survive the surgery and the patient has died. Now the family alleges medical negligence. A district medical negligence board is set up. They call for the doctor comes, the doctor reports that it's an hypothetical case, huh? So bear with me. Doctor will come and say that I first gave the anesthetist he gave the anesthesia. It was as per protocols. Then I cut open the chest. It was as per the protocols. I took the heart out, did whatever procedures I was supposed to do on the heart. Unfortunately, the patient collapsed. These and these parameters, so and so parameters got affected. The patient could not bear the surgery, and the patient collapsed. The patient died. I put the heart back and sealed back the chest. Assuming this was the protocol he was supposed to maintain. Assuming this was the protocol that he was supposed to maintain. So after this statement, the medical negligence board prepares a report that what doctor did was as per protocol, as it was as per standard operating procedures. Nothing wrong doctor has done. Hence, the doctor is exonerated of all the offense of medical negligence, and as a result, the case, no criminal case gets filed. Even in that case, perhaps no civil cases would also be entertained, and the victim family will continue to suffer. They will not get the justice. Now, let's say what happened in the operation theatre. In operation theatre, when the patient was taken in, even before surgery could be performed, the doctor was busy in his own personal recreation. It doesn't happen like that, but I'm saying it's a hypothetical situation. So doctor took the operation very easy, or perhaps he got late. He did not come in time. Anesthetist and other persons were waiting for the doctor. The procedure, even before the procedure could have started, the patient collapsed and patient died. But since here the doctor was late, or doctor was busy in some other activities which he was not supposed to be in, he was not able to operate in time. As a result, the patient died. But after coming out, he prepares the false documents and gives a false deposition before the medical negligence board. Now, it is not even close to reality, but I have just taken a extreme hypothetical solution. Now, here, to decide whether or not the doctor was guilty or doctor committed some medical negligence, first and foremost, medical negligence board should have ascertained that at least surgery was performed. Now, if in case there is no videography available of the surgery, then there are people who are falsely deposing before the medical negligence board that the surgery was done, then the only way to ascertain that at least surgery was performed was to see whether the chest was ever open. Whether in postmortem report it is mentioned that there was a surgical procedure on the chest, or the stitches on the chest suggest that the patient has undergone a surgery. So medical negligence board should have first had a look at the postmortem report, right? Now, if in case that itself the basic thing that the surgery was not performed, the evidence of surgery itself is not there, then the res ipsa loquitur principle will apply. Res ipsa loquitur means things speak for itself, which in most of the cases is only applicable in the civil cases and the law of torts, but here also it will apply. And if the surgery was performed by the doctor itself is not proved, then whether or not he followed the standard operating procedures is irrelevant, right? Now, why have we given you this example? Why I have given you this example is that For example, in Simran Chhabra's case, people are talking about medical negligence. And I say that no, it's not a case of medical negligence, it's a case of culpable homicide because doctor did not perform at all the things which he was supposed to do. And the evidence, the clinching evidence is the postmortem report. And in our case, in Simran Chabra's case, the medical negligence board did not look into the postmortem report. The postmortem report was suggestive of only two puncture wounds on the dorsum of right hand. Right? If that was true, then the doctor's entire treatment which he wrote on the piece of paper, that is his prescription, are nothing but farrago of myths, lies, and absurdity. But in our case, postmortem report, the medical negligence board never looked into the postmortem report properly. So first and foremost, you have to see to it that the medical negligence board reads through the entire postmortem report carefully, and you speak it out in front of medical negligence board to ensure that they look at it. Correct? So that's first and foremost. Second thing is that never ever only go for 304A. The mistake which we do is, no, I am referring to the old provision of IPC. I am not referring to the BNS provisions because a lot of cases would be old cases where IPC would still be applicable. So never ever only allege 304A. Because even in case you are able to get the conviction in 304, even in case, trust me, doctor will never go behind the bars. It's an offence up to with the imprisonment up to 2 years, and even in case the FIR is registered or the criminal trial is done, it will take about 8 to 10 years. Thereafter, if in case he is convicted, the sentence will get suspended pending appeal. Then appeal will be there in the Sessions Court, then the High Court, and the Supreme Court. And by that time, I guess either the family, the doctor himself will die, okay, or the family of the victim will be severely, they will so much of victimized themselves, they will stop following up the case. And again, during this time, a lot of evidences will be lost. Most of the evidence are going to be documentary in nature. They'll become illegible. It will be very difficult to read them. The people who would be there as the witnesses, they would change their places. They would not be available for testimonies or cross-examination. So those difficulties you are going to face. Hence, never ever go in for only 304A. First of all, look for the angle of culpable homicide, that is 304. Again, I'm talking about IPC. Then the most important thing is what doctors indulge into is the falsification of records. They will change the patient records. Please look them carefully. There is a judgment of Honorable Delhi High Court, which is, the case is Pramod Batra versus MCI. It's not a very old judgment, it's a judgment of 2023. This judgment speaks about the falsification of medical records, and I'll just quote one line from this judgment. The Honorable Delhi Court in this judgment said that falsification of records is an extremely serious matter. It partakes of crime and is colored by criminal intent, where the falsification takes place in connection with treatment of a patient, especially where the patient is dead. A seriousness of the misdemeanor increases manifold. So I'll not further go into this judgment. So you will see, once you are going to study the documents carefully, you will see that a lot of falsification records of the patients would have been done by the doctor, treating doctor, or the hospital, which will amount to forgery. Yes, 467 of the IPC. Now, the moment you are going to talk about the falsification of records, you immediately come out of Jacob Matthew. For your case to be taken up, you don't have to go through the rigmarole of Jacob Matthew judgment and then depending on the medical negligence board's report, because Jacob Matthew judgment of Honorable Supreme Court is specifically to the medical negligence. So first you will see the postmortem report, you will study it in detail and ensure that the medical negligence board reads into it. Take a second, third, fourth, fifth, whatever opinion you want. Please do take from the doctors. The problem with the doctors is that it's not that they are bad people; they are good people. The problem with them is that they don't want to get into the issues involved in going to the court. They don't want to be the witness. Second thing is that they don't want to come in open and testify against their own fraternity members. But off the record, they will tell you a lot. Pay their fees, get the opinion. On the basis of that, just see that whether there is falsification of record which has happened or not. If yes, please immediately allege 467 forgery. Okay, and the moment it is forgery, also there is quite a good amount of chance that you will be able to push the case for 304 instead of 304A. But again, that will depend on case to case. In our case, we are alleging 304, not 304A only. So that's one. So these are 2 points. Third point is that if in case you think or you believe, not think, that the members of the medical negligence board, they have made a false report, they have made an arbitrary report, their report is motivated by extraneous factors, please immediately file a separate complaint under section 200 CRPC, or in BNSS it's going to be 225 CRPC. Please file a separate complaint against all the doctors who were part of the medical negligence board. So in our case, most of the evidences which came, they came after we were able to file a complaint against the members of the medical negligence board. Now understand, against the members of the medical negligence board, you are not going to allege 304A. What you are going to allege is the falsification of records, the perjury, etc. So the offenses which will be there, they will be like 193, 218, etc. IPC again I am referring to. So there the magistrate doesn't have to depend on the report of the, doesn't have to comply to the Honorable Supreme Court's Jacob Matthew judgment. No, he doesn't. He won't have to abide by the procedure as laid down in Jacob Matthew. Because here the offense is not 304A, here the offenses are perjury, etc. So your case will automatically be, you will be immediately taken up by the concerned magistrate. So 2 things will happen. Either after the examination of the complainant, the magistrate will issue the summoning order against the members of the medical negligence board, and if in case they have taken money, their report has been affected by the extraneous factors, they'll break. Or second case could be, which would be in most of the cases, the magistrate will order 202 inquiry. Again, I'm referring to CRPC. Magistrate will order for 202 inquiry. Look for a good person in the police, at least of the level of DSP or ACP, who is trustworthy. Make him the inquiry officer. Plead for making him the inquiry officer. Okay, and then considering the second, third, fourth, whatever opinions you have obtained privately from the other practitioners, medical practitioners, prepare interrogatories and help the court to inquire into the matter with the help of those interrogatories. Right? So you will be able to, and then also summon all the records. In that, you also summon all the records that on what basis did the medical negligence board prepare the report? What were the questions? Who were testified? Whom did they ask questions to? Whose statement they recorded while coming to the conclusion that doctor has not committed any negligence? What were the statements? What was the internal communication among the members of the medical negligence board? So that will give you a lot of insights into what has gone into that medical negligence board report. And if in case you are able to challenge the medical negligence board there and then, you make your case of negligence also, right? So I said that I'll discuss 2 cases. Okay, one case is of Simran Chhabra. That anyway, it's all over in the media, so you can just Google it and you'll come to know that what transpired with Simran. The second case, again, this case is me, and I have now I remember I have the consent of the victim's family. So this case is against one of the doctors by the name Sarwar Iqbal. He was, I guess, a urologist or nephrologist. I guess a urologist. And he was working earlier in Columbia Issue Hospital, Sector 23, Gurgaon. And later on, he moved to Max Hospital, Sector 29. Now, this patient's name is Dharmender Sharma. He was suffering from kidney stone. It was a benign kidney stone which this doctor operated on. So he first treated him in Columbia Issue Hospital. Thereafter, he asked him to move himself to Max Hospital Sector 29 on the pretext that Max has some better facilities. Thereafter, he operated him in the Max Hospital, and this case is 2013, 2013 I'm talking about, 2013. And something happened during the surgery. I'll not get into the more details. Now, I'll just tell you what all happened. So, first of all, after the removal of the stone, due to complications, the kidney was removed. Thereafter, there were still complications. Parts of intestines, first part of large intestine was removed. Understand? He's supposed to operate on kidney. Now, what he's now removing is intestine. These two systems they don't have any correlation at all in our anatomy. If in case you look at the human anatomy, they don't connect with each other. Thereafter, he removed the small intestine. After a couple of days, patient dies. What was the age of patient? 32 years. Survival, a Pardanashi wife, or who can barely read and write, and small children. Look at the suffering of the family. FIR gets registered in 2014, 2024, still the prosecution evidence going on. 10 years. How many years it may take? I have got no clue. And will the doctor ever be sentenced? The case in my hand? I hope so. But will he ever go to jail? The answer is no. Why? Again, I said 3048, imprisoned up to the maximum of 2 years, and thereafter, there is a whole lot of appeals. And there is a doctor, resourceful guy. The day he'll think that probably he's going to lose and he may go to jail, he may abscond from the country. There is no provision that we can get his passport confiscated. Okay, so this is the mess. The similar kind of mess you may also indulge into if in case you are one of the victims of the medical negligence. I'll take one more case. Again, here the case is not with me. The victim's family just came to me and discussed their facts. So I don't have the consent of the patient or the victim's family, so I'll not be taking their name. Here in this case, there was a case of high risk pregnancy. So, but before the delivery was done, the patient suffered from UTI, urinary tract infection. The doctor decides not to give her any antibiotics. The patient kept on suffering with UTI for about 2 months. Thereafter, the surgery was done and the baby was taken out. After the baby was taken out, the UTI infection became very severe. It was detected that the UTI infection was because of some multi-drug resistant E. coli bacteria. The patient could not survive because the patient contracted septicemia. Septicemia means when the infection goes into the blood and goes to the multi-organs, it leads to the multi-organ failure, and there is no chance that the patient will survive, especially when the patient is already weak and had just delivered a baby. Here, is there a case of medical negligence? The answer may be yes, maybe no. But the point is that how arduous the battle is going to be. How difficult the battle is going to be. So, so these are the kind of cases which do come. Now here, if in case the patient has to, now I have taken this case because I just want to tell that if in case the case with me, what all I'll be doing immediately. So first of all, I'll take multiple medical opinions. First and foremost, whether she was the fit candidate to have been administered the antibiotics, This is one. Catheter through which was fixed to her. He she Is it that catheter was given the hygiene environment, or the environment itself was contaminated? Because from somewhere she would have acquired that UTI, right? Then, if in case that some doctors will give an opinion that yes, it would have been safe to give antibiotics during pregnancy, then we can allege medical negligence. Now, if in case the doctors say that no, 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 it is doctor's call, one may give, one may not give antibiotics, then the thing is that the why patient has to suffer from UTI for over 2 months, because she contracted UTI in the month of August and the delivery happened in the month of October. So why? How can you let a patient, suffer from a microbiological disease, a bacterial infection for over 2 months? What precautions were taken that the bacteria should not spread? Okay, so this would have been the second medical opinion which I would have sought. Thirdly, if in case was the family informed that if in case the bacteria remains in the body and she is not treated, what problems it may cause in future to her post delivery. Thirdly, if in case there was a chance that the pregnancy could have been terminated, so that this I am saying, if I have not taken any medical opinion, I am saying that I would have taken these opinions, that if in case the doctor would have not given antibiotic because it would have affected the child, the fetus, adversely, then was the family told that let's abort the baby, and because we have to treat that lady, and if in case we have to make a conscious choice between mother and the child, perhaps mother would be the first, survival of mother would be the first option. So were those options given to the family? Third thing is that there was some procedure done just a couple of days before the lady collapsed. Was that procedure important? The procedure may be right, but was it important? Was it required? So I will slowly build by taking multiple medical opinions. And in this case, I don't think so. I would have gone for a criminal case. Yes, registration of criminal case becomes very important because it also helps you investigate into various matters through police, because you do not have the power to investigate by yourself. You don't have the resources. The police can. So a lot of things come as records before the courts. So I would have definitely filed a criminal complaint, but I'm not sure that I would have been able to prove medical negligence, which was gross medical negligence in nature. But at least the case would have been made for the compensation and damages if the negligence was proved. So you have to build step by step. You have to build step by step. And the moment you find that there are records which are missing, there are records which are falsified, there are records which are made up to protect the doctor or to protect the hospital, please immediately allege for forgery, the falsification of records. Because the moment and then if possible, please separate complaints. Because the moment you are out of 304A in your complaint, then you are out of Jacob Matthews. So the entire rigmarole of medical negligence board, you are out of it. You can straight away say that, look, these are the medical records. This is the reason that I am alleging forgery. This is what the falsification of records is. So kindly look into the matter and prosecute. And you then, if in case you are able to build a prima facie case, you straight away go in for the beginning of trial. And here, whenever you're going for 200 CRPC complaint, there is one very good judgment of Honorable Supreme Court, which I use very often. This is Muhammad Afroz Hassan Fata. I'll give the link the correct name of this judgment in the description. So this judgment of Muhammad Afroz Hassan Fata versus State of Gujarat is a very good judgment, in which which clearly says that at the stage of summoning of the accused, you do not have to go in for proving the case. You have to just see whether the prima facie charges can be established or not. So it's a very beautiful judgment. Please use the judgment. I'm sure you'll be able to at least get the summoning order. And the moment you get the summoning order, especially under 467, you'll see the doctor's entire castle of lie crumbling down. So guys, I don't know how much this video would be of use to you, but of late I thought that with so much of medical negligence happening around, and victims and there is no recourse of justice, there is no recourse that victims can take, justice is not in their reach, and the offending doctors, they continue to rule the roost and continue to go unpunished. I thought it's very important that I must make a video which is little more general purpose in nature, and I share my views. Uh, so again, to sum it up, whatever I did in Simran Chapra's case, please do that. First of all, take a medical negligence report. Parallel to that, also look if in case the other offences are made out. For example, falsification of record, which is forgery. If yes, then please file separate court to separate cases. The moment you are filing separate complaints, in the forgery case, you do not have to rely on the report of medical negligence board. So you can straightway pursue it. So it's one. That is the first step. Now, if in case medical negligence board report is formed and they are calling you for your statements, please ensure that you have read the post-mortem report carefully. And then before you enter into that witness box in front of medical negligence board, you have already taken 2, 3, 4, 5, 6, n number of opinions from the various doctors, whether in writing or whether just oral, whether on records, whether off records. So you are well informed what you are doing and what you are alleging. Now, if in case medical negligence board report comes, which is against you, which is in favor of doctor, and on the face of it, it looks like that they have not done a good job, please please file separate criminal complaint against the members of the medical negligence board. They will also crumble. Now, having said that, after you have done all these criminal things, you have an option to approach NCDRC, the Consumer Commission, for redressal, for compensation. But before even you do that, or in parallel to that, please also move a civil court for claiming damages. Now, who all you will make the party? You will make the party the hospital in which your patient was treated. You will make the treating doctors the party. You will make the party, the medical negligence board the party, and in all probability, it would have been headed by the CMO, Chief Medical Officer of your district, and he is employed by the state. So you also make state the party. So this way you do. With the God's grace, if you give a good fight, you'll get the justice.